I thought at first just to give you a little background about the court which we were before, and the court we were before the Supreme Court, which is the High Court. It is important to understand at least some elements as an insider, perhaps I can share with you, some elements of these two institutions. Essentially, Thanks. As far as the High Court is concerned, let me do it backwards. We were before a bench of the Chief Justice at that time, Chief Justice A.P. Shah, and Justice Murlidhar, who was the junior judge. And both of them, the Delhi High Court, as you know, it has a constitutional jurisdiction, as does the Supreme Court. The High Court is recognized in the Constitution of India itself, and you can petition the High Court directly. You don't have to go through lower courts. And particularly where you're challenging a statute or a provision, and you seek to say that this law is against the Constitution of India, then you essentially as a citizen have an option of either going to a High Court or to the Supreme Court of India. Most people prefer going to the High Court because then you have one further tier of appellate review, and in case you lose, you can test the decision of the High Court before the Supreme Court. The High Court of Bombay, for example, would have about 70 odd judges. That's the strength. It just invariably there are about 10 or 15 vacancies because of a little bit of a slack in making the appointments. The Delhi High Court would also have about 40-50 judges. And from these judges, they don't, of course, sit a bank, they sit in benches. And typically in the High Court you have a single judge, and the bench strength could increase to 2. That's generally the biggest bench which you get in the High Court. You have a full bench every once in a while, which is one case or 2 cases every 2 or 3 years. And then once in a very rare while, you would have 5 judges. So there was a time when the Delhi High Court wanted to ensure that the original jurisdiction is retained. So they constituted a bench of 5 judges and passed a very definitive judgment which said that no, we will hang on to our jurisdiction. But usually it's just 2 that you appear before. The Supreme Court has a strength of about 30 or 31 judges, of which we just now I think have about 28 or 29. And typically the Supreme Court of India also sits in benches, and they also sit in benches of 2. Sometimes you have 3 judge benches. The Constitution of India mandates that if you have an issue which is of constitutional importance, and if it involves an important matter dealing with the interpretation of the Constitution, then it must be before a bench of 5 justices. And by almost any measure, Kaushal versus Naz would have been, or ought to have been, a judgment which should have landed up before a bench of 5 learned judges. Now what happened insofar as, now a little bit more about who are these gentlemen, ladies in the Supreme Court. Essentially, they are High Court justices. They are no different from persons who, the personnel of your High Court and the personnel of your Supreme Court are, in terms of qualification, almost entirely the same. That's the pool which the Supreme Court draws from, the justices of the High Court. So the difference, if at all, between a Supreme Court of India judge and a High Court judge is, number one, he or she would normally be a little more senior in terms of having served on the bench, senior in terms of age as well, because apart from doing the High Court stint, the retirement age in the Supreme Court is 65, whereas in the High Courts it's 62. And also, they're generally senior judges in the sense they have served as Chief Justices in one or more of the High Court. So that's the pool you're looking at. Now, I believe, in retrospect, I think in Naz Foundation, we got really lucky in terms of the bench which we had before the High Court. And oftentimes, after the judgment was rendered,
in favor of NAS and the groups that supported it, I was looking back and thinking of, were there any other two judges in the country whom I would rather have been before? And even before the judgment was rendered, just having regard to the sensitivity which the bench displayed during the hearing, I think that was probably the best bench which we could have had. So the petitioners in NAS, the writ petitioners, really got lucky. There's a strategic element to this which is very important to remember. Some of you may recall that when NAS was initially heard by the Delhi High Court, it was dismissed. And it was dismissed by a Chief Justice, Justice Patel, sitting with, I forget the junior judge. And then it was carried by NAS to the Supreme Court of India. And the Supreme Court of India bench at that time, which had a bench strength of 4, said that this ground of dismissal by the High Court was really too technical. The High Court basically said that, look, there are no real instances which have come before us where this particular law has been abused, and we are not going to decide the matter in the abstract. And so when the matter reached the Supreme Court said, this is plainly wrong. On an issue like this, which affects so many people and which is of such importance, of course the High Court must decide. And so it sent the case back to the High Court. And in a strange way, the eventual judgment in Kaushal sort of goes back on what a 4-judge bench of the Supreme Court had said just a few years earlier in the very same case, which is, this is not about individuals or specifics or about violations in a particular case, but a much broader and larger issue, which is why the case was remitted back. Now, two things stand out. And when I look back, I think of a meeting that I attended as a member of the Bombay High Court Bar. I remember it was in our bar library, which unlike most libraries is where we generally chat and discuss, generally slander people left, right and center. But after court timings, every once in a while, there is a talk which is given there. And I remember now a talk which was given by Justice Kirby of the Australian High Court and Justice Cameron, who now serves on the Constitutional Court of South Africa. This was many, many years ago. And it was a packed house in terms of members of the bar. But interestingly, there were also members of the Bombay High Court who were present. And in that lot was Justice A.P. Shah. And it was a dramatic speech. It was this sort of Punch and Judy kind of show where Kirby and sort of Cameron went at each other, but they made a beautiful pitch. And Cameron then came out and said that he was HIV positive, and he went and sort of hugged people. And it was a powerful moment of education for the judges. And I'm pretty sure that Justice A.P. Shah carried away with him a degree of sensitivity which he probably didn't have when at the beginning of the talk. He probably, this opened his mind to a whole world over there. And I should think that insofar as Justice Muralidhar is concerned, at least going by the kind of academic writing, compilations, the sort of causes he espoused as a lawyer, I should think that he also had that sensitivity and the ability to sort of lift himself up from technical issues of the law and really search out the issue behind this case. And I think this is where, as lawyers for the parties who are defending the High Court judgment, we perhaps failed in the Supreme Court. I think we failed in building a bridge across to the Supreme Court justices and educating them, at informing them and increasing or sort of imbibing in them the degree of sensitivity which a case and an issue like this required. And so when you read the judgment, it's such a dry kind of weak sort of analysis, very weak on analysis. But what it lacks is, I believe, two big things. These are the two big flaws that I see in the judgment, and it was at a certain level, I suppose, a communication flaw on the part of those of us who were defending it. Flaw number one is the Supreme Court forgot about its role. I mean, you would expect surely that a judge like Justice Singhvi, who spent a whole career in the law, on the last day of retirement, would know something about what the Supreme Court is about and what its role in society is. So that's flaw one, which I'll come back to. And I think flaw two is it forgot, or it failed to notice, that the case was about identity and the case was not about sexual acts. I think that's the big miss insofar as the Supreme Court judgment is concerned. I mean, you can, debate endlessly on the statute and the contortions and this action and that act and against the order of nature. But the case was just not about those acts. It was about a certain segment of society which said, hey, this is our identity, recognize us for who we are. And the court just didn't realize it. But coming back to the first issue, which was the role of the court, I think the role of the Supreme Court of India, more than anything else, is not just to act as an appellate court and to hear appeals from the Delhi High Court judgment. I mean, that is the usual business of the court. The real function of the Supreme Court is, as I see it, to protect human rights, to expand rights, and to reveal new dimensions in our apex law, which is the Constitution of India. And this is where the Supreme Court failed. When you see the judgment, it says the High Court is wrong on this, the High Court is wrong on that, the High Court ought to have done this, and the High Court ought to have done that. But that wasn't the business of the court in this case. That could very well be the business of the court in a general commercial action or in other types of matters where there is, some dispute between private entities, or indeed even in disputes between entities which are private and the state.